Hi, very good morning. This is a case under Negotiable Instruments Act. Supreme Court, Rajco Steel Enterprises versus Kavita Sharaf and others. Interesting case. Complainant is a partnership firm. They gave four checks to the accused. All the checks bounced for insufficiency of funds. One of the partner of the firm initiated a case under Section 138. Case before the trial court was financial assistance was given to the accused. Checks were issued uh, for financial assistance. Accused denied the same. Her submission was that she was undertaking stock market related transactions for the complainant through her account. The complainant did not want his family members to know this, hence, this sort of arrangement was made. The claim of the accused was that blank signed checks were given on good faith to the complainant. The complainant used to deposit whenever profit is there. That was the arrangement which was done. The main case of the accused was it was not a financial assistance, there was no debt. So that is the case. Trial court held that checks were issued in discharge of a legally enforceable debt, and hence the trial court convicted the accused. Appeal was filed before the first appellate court. First appellate court set aside this order. The court said complainant failed to produce any documentary evidence showing any loan transaction. He failed to prove handing over of checks by the to the accused. Further, the court also noted the signature and amount in the checks were different in inks. So the ink, the signed check was signed in a particular ink, the amount was filled up in a particular ink. So it said there is a difference. On the above grounds, it set aside the order of a trial court, appellate court. The again appeal was filed against this before the High Court. High Court said no documentary evidence was produced substantiating the existence of any enforceable debt. High Court applied the principle of balance of probabilities. It held a case has been made out for non-existence of any legally enforceable debt. High Court observed that the balance sheet and accounts statement of accounts of the accused reflected a sorry state of affairs for the finances, and it concluded that accused could not have undertaken such a transaction because poor accounts, there was no big transaction. So it must have said that it is showing a poor state of affairs. Then appeal was filed before the Supreme Court. The submission was signature of the accused and receipt of money to the account of accused was proved. Complainant has given that it is proved. These two remain undisputed. Whether have you issued the check? Yes. Have I gave the money? Yes. These two remain undisputed. Hence, the ingredients of Section 138 are proved. Once these are proved, complainant need not prove anything else. So it need not prove that there was a debt in the manner. It is required to be proved in a civil court. So there I have to produce everything. Under Section 138, I have to prove two things. One, check was issued. Two, money was received. That is enough. If that is proved, the burden of proving otherwise will shift to the accused. Mere denial is not enough. That was the submission before the Supreme Court. Supreme Court held under Article 136 of the Constitution, jurisdiction to interfere with the concurrent findings of the fact is very limited. It can interfere only when such findings are based on no evidence or perverse. This is a settled law. Now the question is whether the findings of the appellate court are perverse or based on no evidence. Supreme Court said both the courts, the appellate court and the high court, examine the case threadbare. Further, complainant failed to show if any sum was advanced towards financial assistance. Other partners are silent. They did not depose that the checks were given for financial assistance. Accused has put up a plausible case. Appellate courts, on going through the documents, did not find existence of any enforceable debt or other liability. On that basis, Supreme Court also dismissed the case. So, how many evidences have to be produced? Who are all to be brought in before the court? From this case, we can learn. That is what I wanted to say. Thank you very much. Have a great day.